Thank you.
Devine and the Secretary's note delivering our county and communications.
Yes, Miss Ollie.
May it please the Court, I appear for the appellant and my learned friend, Mr. Freddie Humphreys, appears for the Secretary of State respondent.
Yes.
The interested party is represented.
No. Thank you. Well, you can take it that we have read the papers, familiarised ourselves with the issues, of course read the skeleton arguments, including your replacement skeleton argument, Miss Ollie. And Mr. Humphreys, you've had the opportunity to consider whether you wish to respond to that and have decided not to.
Yes, I was content that
not to do so.
Arguments are fully addressed in the
yes. So we've read all of that material. So, Miss Ollie.
I'm grateful, my Lord. The purpose of the further skeleton was not to throw a spanner in the works,
no.
as it were, but to set out what I thought I would say orally, and I wanted to give Mr. Humphreys a chance to.
Yes, no, that's helpful. Thank you.
I'm grateful for the permission to rely on that.
Yes.
I don't. Sorry, my Lord.
So that stands in replacement of your previous skeleton argument.
Yes.
Yes. Fine.
And we as the legal team, we thought through, realised perhaps we hadn't thought through to logical conclusion, but the one aspect in relation to the East Wing, we thought it was important that was.
And that's fine. It's understood as a replacement skeleton argument. Thank you.
So I don't have an enormous amount to add to that. What I would like to do, if it's convenient for the Court, is to go straight to the decision.
Yes, of course.
Of Inspector Harbottle, which is in the core bundle from page 118.
Yes, thank you.
And then I'd like to touch on the case of Sage and perhaps briefly the case of Hillside.
Right.
Make any further submissions, and then those will likely be my submissions. So
yes.
the Inspector, of course, starts his treatment of Ground B. I'm not under any illusion in relation to Ground B. Obviously, there was not permission. There's no permission granted to challenge his findings on that ground. But the reason why I'd like to go through that is because we'll see the dates that were mentioned and not mentioned, and it will set the scene for the treatment of the challenge on the Ground D appeal.
Yes.
So that starts at paragraph 8 of the decision, page 119.
Mm-hmm. Yeah.
So, respect to records that the appeal relates to the alleged erection of a new building, and then paragraph 9, the appellant carried out many of the works in an incremental manner in his own time and over several years. A few records were kept. The burdens on him to show the works hadn't cumulatively resulted in a new building. So that the first point is the eastern wing, which changed the building from an L shape to a U shape. That was done between 2001 and 2004. So it's new in the sense that the inspector defined it to be. In other words, it happened after the appellants bought the property in 2000. So that's what he means by new there.
So that's the eastern.
That's the eastern wing, the part that turned the building from an L to a U.
Yeah.
Essentially. I might take your lordships and my ladyship to the plan in the supplementary bundle.
Yeah.
At some stage.
Right.
So that's before 2015 is the point I'm making there, being the operative date, March 2015.
Yes.
Subject to the point I make in the skeleton. Paragraph 11.
Yeah.
Concrete floor and damp-proof course. We haven't got a date there. Of course, there's no reason for the inspector to have put dates in at this point, because he's just describing what was done rather than when it was done. Mm-hmm. But we know that there isn't a date there. But this was done before 2015, as we will see.
Mm-hmm.
The northern and western wings. First, the walls. So the southern gable was rebuilt, and then over the page, new roof added in or around 2007. So again, before 2015. And then moving on to the internal walls, new blockwork, replacement of original fabric, elevations have changed since 2000, including removal of render, alterations to door window openings. Some openings have been bricked up and were opened again, and and the appellant reinstated some of them. Now, we haven't got any dates here, but we'll find that from what the appellant had said. And then there's the point at paragraph 14 about the bricks that he took from the inside and used to repair some of the outside. So the dates here we've got between 2001, 2010, 2001, 2003, 2007, 2008, as the court can obviously see, all before 2015. And then we get to the point where the inspector says there was an ambiguity. Now this ambiguity seems to be, as far as the inspector is concerned, just in relation to how many bricks were actually reused. So it doesn't seem to extend beyond that, and he sets out the clarification that happened there. Still, though, before 2015, and go on. It goes on to talk about that, about the brickwork still through paragraph 17. Paragraph 18 again, we're talking about window openings changing to the elevations. This is a major elevational changes from what existed in 2000. Now, my submission is, well, there may well have been, but the crucial point for today is when that happens. It's not so much what happened, but when it happened. Paragraph 20, the inspector moves on to deal with the roof, which was absolutely the appellant's case, that the roof was replaced in its entirety because it had to be. It was rotten, there were holes in it, and the court may have seen that from just a few photographs that remain in the bundle. And then yes, the inspector goes on. Now, I will just want to draw the court's attention to a couple of points. And I know I'm in the ground B section, but there are just a couple of places here I'm going to pick up later when we get to ground D. In terms of the emphasis the inspector placed on intention, and I'm going to be submitting that after Sage, that was an impermissible line of inquiry. So we see a reference to intention at paragraph 25, where the inspector says it's not known what works the appellant contemplated and intended to carry out when he bought the building, although he began using it for his building and joinery business after making the roof watertight. So that's the first reference. And then also at paragraph 26.
Yes.
Require a substantial leap of imagination to view this repurposing of building as an unplanned consequence of nothing more than repairs and improvements. And of course, we say, well, it was speculative. That's what the appellant desired, but he hadn't actually put that in place. So intention is a completely impermissible line of inquiry, which is what we take from the case of Sage. Focus on fabric.
Do you want to look at Sage?
I would like to, my lord, yes, and it might be more convenient for me to go to it in a moment.
All right. No, that's fine, of course.
So that we don't jump about too much. So that's what happened, and I will go to the appellant's own statement as well, if I may. But then when we go on to the ground D appeal.
Yes.
The question here is obviously whether what has been done before the relevant date in 2015 or not. And I suspect the court is well aware of my argument. I've made it several times at various levels, that the inspector has started from the assumption that this is a dwelling in the course of construction. Thus, the focus right at the outset on the lack of heating and sanitation, electric work being incomplete, and doors and windows not to be inserted, as it had been inserted.
Right.
But what we don't see in this section, paragraphs 38 through 43, is an analysis of what has been done against the dates. What we see, at least from the ground B section, and what we will see also from the appellant's evidence, is that everything substantial happened before 2015, apart from the repair of the roof. Hence, we've said, well, the roof of any building might need replacing at some stage. It doesn't mean that the building wasn't already substantially completed.
I mean, would it be fair to say, do you think, that if you're I'm not saying that's the facts of this case, but if you are constructing a new building, the last thing you do normally is to put the roof on?
I'd have to defer to my client's greater knowledge, but yes, I'm sure that's
probably is right, isn't it?
As
a generality.
And as a generality, yes, my lord. Yeah. But of course, if there's already been a roof put on, then the building came to be completed at some stage. But if it was then replaced, it would be taken off and put back on. And the key in this case is that there had already been a roof.
Yes, I mean, one would remove oneself from the facts here for the moment. One can envisage a situation in which a rotten roof has to be removed and then a new roof put on, replacement roof put on. And that could, in certain factual circumstances, be regarded as a repair to the building, depending on, as a matter of fact and degree, on what had happened to the rest of the fabric before that. So those two propositions, which are removed perhaps from the facts of this case, would seem to be reasonably clear, wouldn't they?
Yes. But on the facts of this case, there was a barn which was complete, and it was complete when the appellant bought it, but he realised that it was rotten and needed replacing in its entirety. But if it had changed into a partially constructed dwelling, then yes, that might be different. But the point was that there wasn't the evidence before the inspector to conclude that. And so he was simply replacing the roof of a building that had already been completed. Well,
I wonder whether this comes close to the heart of the case. I'm not sure that it does, but let's just consider this for the moment. If leave aside, if you like, leave aside intention altogether for the moment. But if one starts with a barn that's 100 years old and in a poor state of repair, there could be a factual situation, couldn't there, in which, bit by bit, incrementally, if you will, the owner of the building replaces this bit of fabric, that bit of fabric, another bit of fabric, and eventually all the fabric, let's say, is new fabric. It's done in stages over the years. And it is possible, isn't it, as a matter of fact and degree, I'm not saying that's this case, but as a matter of fact and degree, an inspector could find that that constituted a new building. Is that not right?
It would have to be open to the inspector to conclude that. Otherwise, it would be cutting down the test, which is a matter of fact and degree decision maker. So, yes, my lord. And I put the sort of philosophical point in at the commission stage, and I haven't troubled the court with it since, but I use the possibly analogy of a painting being restored.
Oh, yes.
So
there comes a point at which it's not the work of Cézanne any longer, it's the work of the restorers.
Talented restorers.
Yes.
That was the best analogy, I suppose, that I could come up with. But it does require one to step back, and that's why, albeit we can't argue that today, but under the Ground B appeal, we said that this focus on fabric is misconceived. It should be more on form and mass. Is the footprint largely the same? Is it still a barn, or has it become something completely different? Use a vernacular, someone putting a fast one and just constructing a residence in place of what was there before.
You said just now, let me just be clear that you did say this, the focus on fabric is misconceived.
Yes, I can't argue that today, but just while we're talking about it, yes, it shouldn't be a question of what's because the inspector faithfully followed the evidence about how much had been reused.
Yeah.
I think it was taken down a wrong path there, because he's saying, well, 20% or 25%. not much of the brick that's there now is the original brick. It's been brought on from outside. And so he's used that as his test, really, for whether this is a new building. We say, well, if we had a chance to say, well, it still looks like a barn, and it just doesn't matter that some of the bricks are new. He tried to use the old ones, knock them down, and some of them broke. But regardless of whether we're right or wrong about that, most of the key work was done a very long time before 2015, and it doesn't matter that he changed the roof. He could have changed the roof in 2012 to 2014. It happened to be 2015 to 2017. So that's quite matters for the purpose of the service of the enforcement notice. But it could only ever be seen as a matter of repair. And it's clear from the evidence that it needed to be done because there were holes in the 125-year-old roof.
Yes.
So it's not that repairing the roof somehow turns it from a barn into a different kind of building that hasn't been constructed yet. Except that in the case of the eastern wing, I think we unfortunately do have to accept that wasn't there before. We can't say that that was ever a completed building and the roof was just...
No, the eastern wing wasn't there before.
Even though most of it was built. I mean, I'm not instructed to make that formal concession, but I think it's the logical conclusion of our argument.
No, and I think you do say that in your replacement scales and argument. Yes. Well, we understand the submission you make.
I'm grateful, my lord. So it really just comes down to these short paragraphs in which the inspector, my submission, is clearly, one, impermissibly taking into account intention, and on that alone in my submission it should go back to be looked at again in accordance with the law as explained in Sage. And secondly, he has been led to look at the matter through the lens of the sort of suspicion-tainted spectacles, not rose-tinted. There's suspicion that the appellant was trying to create a dwelling. We've made the points in relation to the evidence that he's a builder. He's clearly able to do any operation that he wants to carry out. He's able to achieve. And so, if he wanted to construct a dwelling, logic suggests that in the 20 years since he bought the building, he would have done so, but he didn't. And it was, and he said quite clearly, we went through this before, a learned judge, Mr. Justice Fordham, he would very much like to have permission to turn the building into a dwelling, hence made a series of planning applications in 2018. But those weren't retrospective, he hadn't already done so, they were aspirational, excuse me. I'm sorry. The local authority didn't visit the site until those applications were made, and so of course we're looking for a residential building, and of course didn't find one because it lacks heat and sanitation. Doesn't look anything like a dwelling. It still looks like a barn. So that's where it's gone wrong. If one was looking for a dwelling, one wouldn't find one. Therefore, one would conclude it's not substantially complete as a dwelling. Therefore, the enforcement notice was served in time. But if one sees it for what it is, as a barn, then the position is different.
Right. Thank you.
So I don't wish to repeat myself, my lord. I mean, that really is sort of the long of the short of it. Those two criticisms of the inspector's approach under Ground D. He's looked at intention, shouldn't have, and the fact that he's looking for a dwelling rather than looking at what is actually there.
Yeah, those points are fully developed, I think, in your skeleton argument.
I would respectfully suggest that they are, my lord, so I don't want to take the court's time.
No, that's fine. But not at all. But that's helpful. If you want to take us to any particular aspects of the argument that are on paper in your replacement skeleton argument, which you haven't emphasised orally, then of course you may and should. We give you that opportunity.
I beg your pardon. It might be helpful to go at this point to Sage.
Yes. All right. Yes. We'll take that Sage.
Tab 3.
Thank you. Yes.
So the factual difference in this case
Yes. Yes.
Is that we do have a partially erected dwelling house, and I appreciate it was suggested in argument that it's an agricultural building now, but this was something that was heading towards being a dwelling. So that's just as part of the background. A significant contrast with this case. It was something being built anew. We see Lord Hope at paragraph 6, which seems to touch on intention. I know a friend and I discussed that with Mr. Justice Fordham in the High Court. We agreed that it is reconcilable with what Lord Hobhouse later said around paragraph 14. But Lord Hope does say at the end of paragraph 6 that regard should be had especially to the building's physical features and its design. I note paragraphs 7 and 8. So paragraph 7, be wrong to treat the building as having a character which the person who erected it never intended it to have. But if it's shown that he stopped short of what he contemplated and intended when he began, the building as it stands can properly be treated as an uncompleted building against which the 4-year period has not yet begun to run. So here we've described it as repair and improvement. It's a restoration, really. That's probably a better word for what happened on the facts of this. Paragraph 8. It's not for the inspector to substitute his own view as to what a building is intended to be for that which was intended by the developer. It's not what the inspector did in this case. It was not just that the building looked to him like a dwelling house that was in the course of construction. His conclusion was supported by an application made to use the building for tourist accommodation. His finding that remained Mr. Sage's stated intention. And then if we go on to the main judgment, that's of Lord Hobhouse.
Yes.
I should say, I apologise. Paragraph 13. The inspector started by considering Mr. Sage's contention that it was an agricultural structure and therefore he never needed any planning permission to erect it. So the reliance slightly different there. He considered how it was constructed and concluded that it was constructed with domestic, not agricultural features, as a dwelling, not as a building to be used for agricultural purposes, and then it goes on to give the details of that. 3 elevations clad with tiles, 4th with timber boarding, upper floor with further demonstration, no stairway. Now, clearly, because this building's already been built and was a barn, then again it's different on the facts from this case, in which something was being constructed anew. At the end of paragraph 13, he applied the test of physical layout and appearance, and then Lord Hobhouse went on to say, the inspector rightly did not investigate the intentions of Mr. Sage at various stages in the history, nor the uses he had made of the structure from time to time. So the court there is holding the intentions shouldn't be investigated, and I sought to show in the decision letter that the inspector very much did focus on intention. Lord Hobhouse continues, the character and purpose of a structure falls to be assessed by examining its physical and design features. So the fact that the appellant in this case might, even if he replaced all of the bricks, the design would still be that of an agricultural barn, but that would be its physical features. Going back to Lord Hobhouse, the relevance of the assessment is to determine whether or not the building operation is one requiring planning permission. The actual use made of the building does not alter the answer to be given, and he gives a couple of examples there.
Yes, there are some quite graphic examples.
Graphic examples. Yes, my lord. The starting point for considering the permitted use of a new structure is the character of the building for which permission has been given or does not require to be given.
Yeah.
And then there's a reference to the inspector's conclusion. As a matter of fact and degree, he considered having regard to its layout and appearance, it's not an agricultural building, was not designed as such. Best described as a dwelling house that was in the course of construction. So we don't have that here. We don't even have that finding here. Would be wrong in any case on the evidence. The court, so having read the evidence and considered the photographs in the papers, the inspector's conclusion on this point would seem to have been inevitable. And so the argument then turned to the points that had been made before the High Court, and of course, I don't think I need to go into those particularly. But if we go on to paragraph 19,
yes,
the question of fact whether the external work still to be done would have had a material effect on the building's appearance. Obviously, that was in the context of the argument that one would only need planning permission. One should look at what remained to be done, and did that need planning permission? And the court said that's just a very complicated way of looking at section 171B and would go against the whole point of enacting it. To summarise.
yes,
About halfway down. Once it has to be accepted in accordance with the inspector's finding that the structure was a dwelling house in the course of construction, it follows that the work will be properly described as work carried out in the course of completing the construction of the building. Exception A clearly contemplates and involves a completed building which is to be maintained, improved or altered. So simply make the point that here that the essence really of the case is that we do have a completed building here.
yes. Here you say the completed building is the original building. Is that right? For the
Yes.
purposes of that proposition in Lord Hobhouse's speech?
Yes. No, I've got to be careful that I don't then effectively try to challenge ground B,
Yes.
because the inspector's found it to be a new building. So, but nonetheless, there clearly was a completed building, and that was not controversial.
So what do you say was the completed building?
The completed building was what was there in 2000 when the appellant bought it, but then we're constrained to accept that there was a new building.
So the completed building was the building as it was in 2000,
Yes.
when he bought the site.
Yes, and that's and that goes to how one judges whether the substantial completion of the new building, because one has to then look at the physical design, the layout, and that's dictated by what was there in 2000, unless it had changed radically, but it hadn't.
So what then was the new building?
So then we've got a substantially completed new building, as the inspector found it to be, which is the eastern wing, the changes to the gable, southern gable change, tinkering, I'll use that term advisedly, with the position of the doors and windows, putting the inner block work inside, taking the inner bricks and moving some of them outside. All those things which the inspector found meant that it wasn't the same building, because essentially he brought new materials on site.
Yeah, so a substantially completed new building before the relevant date.
Yes.
Which wasn't the original building.
As I'm constrained to accept before your lordships and my ladyship, yes.
Yeah.
There was a new roof, but because it remains an agricultural building throughout, he simply replaced it. So he's not, excuse me, he hasn't changed the agricultural barn into a partially constructed dwelling that hasn't got a roof yet. The roof is already there. It's just rotten. Timbers are rotten.
Right. Agricultural building throughout, replacement roof.
Yes. Yes. So that's why I say that there's a clear way through the fact that I wasn't given permission on ground B. It doesn't matter, except the findings about what was done when, for the purposes of my argument, what was done, but it's a question of when it was done. And the substantial work was done before 2015. There were actually repairs to the roof made throughout, really, from time to time, as we'll see from the appellant's statement. So it's not the case that the roof wasn't there anymore, and he eventually got around to putting it on top. There was always a roof. So that wasn't part of the changes that were undertaken that caused the inspector to say it's a new building. It was the work done to the walls and the construction of the extension, the change to the gable, changing the milking pens into a level floor, putting a damp course, all those things seem to have led the inspector to conclude, well, because he's focusing on fabric, this is new. But the roof didn't have anything significant done to it until 2015.
Right.
So I suppose the new post 2000 building had the old roof anyway. So it was a new building with the old roof. But then that was changed, and so that's why it was simply a matter of repair.
Right. Thank you. That's clear. Can I just stand back and ask your help with one other question? Would I be right in saying that there is no, in your appeal, there is no direct attack on any of the inspector's findings of fact as such?
Yes, you'd be right.
Thank you.
So,
right.
Staying within Sage, also
yes.
Noted paragraph 23, but it's the same point, right at the bottom of the page, paragraph 23, referring to a case where the building's been completed but was then altered or improved. So I've just spent a few moments.
Sorry, just exactly where were you then?
At the very bottom of paragraph 23.
Oh yes.
Which is the same point actually.
Yeah.
We go on to the speech of Lord Scott.
Yeah.
Which, in my submission, poses some interesting questions which didn't arise on the facts of that maybe of assistance.
Yeah.
I noted paragraphs 32 and 34. So paragraph 32 just records, in the present case, Mr. Sage, without planning permission, commenced the building of the dwelling house, but when it was still uncompleted, he ceased his building works. But it had reached a point at which it was capable of use for other purposes, in particular agricultural. So it's just a point of interest. The court noted that. And then again, paragraph 34, the inspector had looked at having regard to its layout and appearance. He didn't think that it was an agricultural building. So, but it's a clue as to the test that should have been applied in this case. It should have been applied according to the layout and appearance, and not according to the appellant's intentions. And then Lord Scott, interestingly, in my submission, discussed what would happen if something started out as one thing but arguably became another thing.
Yeah.
Which is quite helpful.
Which paragraph is
so
that?
Paragraph starts at paragraph 36, explained the concern that he had. So, Mr. Sage building what was intended to be a dwelling house. Then he says the classification of a building is not immutable but can change if the use changes. not uncommon for barns to be converted into dwellings, or indeed vice versa, which we see at paragraph 37. Just take note of that passage, but it's perhaps paragraphs 41 or 43 at the end that I particularly noted. So if I may go to paragraph 41.
Yeah.
Lord Scott says, in principle, there must be some time limit after which it would no longer be open for enforcement action in respect of the original planning breach to be taken. The present case may be taken as an example. The building works ceased in 1994. The enforcement action was taken in 1999. Let it be assumed that at some point between those two dates, Mr. Sage decided he would not complete the originally intended dwelling, but would instead use the structure for his agricultural purposes, and that he thereafter did use the structure for those purposes. It cannot, in my opinion, be the case that for an indefinite and open-ended period, the council would remain free to commence enforcement action, contending that the structure still remained a substantially uncompleted dwelling house. Such a state of affairs would, in my opinion, be inconsistent with the scheme of section 71B, and then he's paragraph 42. It doesn't help Mr. Sage because it wasn't the facts. But, paragraph 43. So no submissions as to how section 171B would be applied if it was that case. It seems to me, however, well arguable that it would no longer be open for enforcement action to be taken in respect of an uncompleted dwelling house if a period of more than 4 years had elapsed since the structure had become de facto an agricultural building. Nothing in the result of the present case decide that issue. The reason why I draw the court's attention to that discussion is in view of the observation made by Lord Justice Coulson in granting permission. Really saying, well, how does one apply the 4-year rule in a case such as this, where you've got, repairs ongoing, really forever, as it were, or the whole of the period since which the appellant has owned the building. I don't profess to have the definitive answer to that, other than to say that it may lie in how one understands repair, and it may require one to be astute, to take a step back in each case and look at what is really in front of one when deciding. But there's, I suppose, a caution sounded by Lord Scott in paragraph 41. If it doesn't get to the point of being a dwelling house, and it could be used for something else, then time has got to stop running at some stage. And the relevance to the appellant's case is that on our submission, regardless of what was done, it remained an agricultural building. It's nowhere near the point at which one could look at it and say, oh, well, that's a dwelling house in the course of construction. And the fact that the appellant made planning applications, as I've said, is purely aspirational. He's under no illusion of getting permission for that. But he was honest about the fact that, yes, of course, he'd very much like to have permission for that.
Does the inspector rely in any way on those applications for planning permission?
Yes, my lord, he very much does in my submission.
Right.
Yes, paragraph 26 of his judgment. Yes, it actually starts at paragraph 25, so page 121 of the core bundle.
Yeah.
It's not known what works the appellant contemplated and intended to carry out when he bought the building. Although he began, I read that sentence, began using it for his business. Nevertheless, the 5 applications he made in 2018, after he retired, confirm it was then his intention that the building should become a dwelling. I don't know where this point lies in this appeal, but we challenge that because it's just a matter of general planning practice. An application can be completely speculative. If it's retrospective, then I think the die has been cast, but it wasn't. And bearing in mind that he could have converted the barn to a dwelling or dwellings had he wanted to, and had plenty of time to do so. It's telling that he didn't, nonetheless. And in any event, this is bringing in the question of intention rather than focusing on what does this building look like. It's a great big barn. And the appellant actually said in evidence that if he wanted to change it to a dwelling, he'd have designed it completely differently because it wasn't a handsome-looking building, and that point's recorded. But I think to answer your lordship's question more precisely, it is paragraph 26. The elevations and floor plans in those applications are marked existing and proposed, indicating that any structural or elevational changes the appellant deemed necessary for residential use had already been carried out. Well, again, we challenge that because that doesn't necessarily take it from an agricultural building to residential, except for a porch and the insertion of doors and windows. The drawings show the building as it is now. We don't have those drawings in any case. It wasn't a large part of the inquiry.
But you say that in 26 he was relying not on the physical form of the building as such, but on the intention that lay behind the work that had been done.
Yes, I am, my lord.
Right.
So he says it would require a substantial leap of imagination to view this repurposing of the building as an unplanned consequence of nothing more than repairs and improvements. So those are the suspicion-tinted spectacles that I mentioned earlier, and that's clearly the lens through which the local authority regarded the matter, and that was specifically accepted in cross-examination as well.
There is a distinction in Sage, but perhaps in the authorities as a whole, between intention and purpose, isn't there?
Yes.
You could say the purpose of the building is residential. On the one hand, on the other hand, you can say the person who undertook the works to create the building that is there on the site now was an intention in his or her own mind to create a dwelling house. Those two are different propositions, I think.
Yes.
Is that right?
Yeah, yes. And on in my submission, my reading of Sage, the court is saying that you shouldn't investigate intentions, but you should look at layout and design and character and purpose.
Purpose is within range.
Yes.
The purpose of the building, as we say, is properly within range. Yeah.
Yes, that in my submission, that derives directly from Lord Hobhouse's speech at paragraph 14. So, with respect, the inspector has fallen into error by focusing his head on intention.
If he did, yes.
Should the court find that, then yes.
But that's your submission.
That's my submission. That he's focused on intention rather than the purpose of the building. He hasn't considered any competing explanation for the works of restoration that were done. He has very much proceeded from the assumption that this was going to be a dwelling. So when he starts to look at the Ground D appeal, he immediately says at paragraph 38, well, it doesn't have heating, it doesn't have sanitation, bathroom, electric work, no doors and windows. The appellant's case was, well, no, respectfully, of course it doesn't, because it's not supposed to be a dwelling at this point. I haven't taken steps to turn it into a dwelling.
Mm-hmm. Understood. Yes, thank you.
So that's what I take from the Sage case for purposes of my appeal. Put in the Hillside case at 6. Now, of course, this is a Pilkington matter, and not a case quite in the same vein as Sage. It does discuss Sage.
I think this case would be very familiar to my lord.
Yes.
Yes. What do you draw from Hillside?
So I don't want to. We'll just go straight to the discussion of Sage runs from paragraph 56, but it's paragraph 62, the section of those few paragraphs following paragraph 62. It's page 99.
Yeah.
It's important to recognise that in the Sage case, no planning permission had been granted for any of the building operations carried out. The remarks of Lord Hobhouse about that were over to the ratio decision. There's building operations carried out without planning permission are not substantially completed until construction of the whole building contemplated by the landowner is substantially completed. It was the requirement to have regard for this purpose to the whole of the development contemplated by the landowner, which was characterised as a holistic approach. So the evidence in this case was that nothing was contemplated beyond repairs and restoration. That the tinkering, as the appellant put it, treating it as his hobby, with nothing beyond an aspiration to one day be able to turn the building into a dwelling or dwellings. He hadn't done that in all the time that he'd been restoring it.
Right.
Obviously, in the context of inconsistent permissions, that the following paragraphs have to be read. That the point is made, going down to paragraph 66, that what has been built out so far shouldn't become unlawful.
I'm sorry, which paragraph?
So paragraph 66. So where the permission couldn't be carried out fully, would that mean that what had been done so far would become effectively unlawful? And the Court of Appeal said, no, that can't be right. There's no authority for that. And their lordships said, we agree. So the court may or may not find that to be analogous to this particular case. But clearly, my facts are that buildings, it's there, it's already being constructed, should be rendered unlawful because the roof is replaced within the 4-year period. Then, my lords, my lady, I was proposing to make good, just so that we've got the reference conveniently to hand, the points I make about the dates, which I looked at briefly in the inspector's decision. My criticism being that there aren't enough dates. There should have been more dates because they were before him in the appellant's evidence.
Right. So which dates do you say were lacking?
So that would require us to just go into the supplementary bundle, if we may. I'll take the court to Mr. Devine's statement.
We can put away Hillside, can we not?
Yes, my lord. I draw the court's attention because of the discussion.
Okay, yes. So, to Mr. Devine's statement, is it? In section 8?
Yes, my lord, it's page 92.
92, right. Yeah. So this is.
He's running through with reference to the photographs, which we don't any longer have, but he's just explaining what he did and when. And there's also a 2-page handwritten note about page 162, which I'll go to in a moment as well. So he just the court. I'm sure has already read through this, but it might be worth going back to this.
Yeah.
So paragraph 3. So paragraph 1, June 2000, Appellant. Paragraph 3, 2001, 2002. I started to restore windows that had been bricked up. Did most of that by 2010, apart from a couple. So I would say that doesn't mean that there's no substantial completion just because a couple had been done. 2003 there was a storm that damaged parts of the repaired roof, replaced it with metal sheeting. Over the page, paragraph 5, 2004 rotting timbers replaced at the end of the southern gable. 2005 paragraph 6, I removed the render. Paragraph 7, 2006 2008, continuing work on the barn, which he calls his project. I decided to construct inner block walling. Now, just to alight here, he's calling it the project. I mean, it's a small but important point. When he says project, he means everything he's been doing since 2000, not just what he might decide to do after 2015 when he retired. So that's how he defined his project. So the inner block walling, and this is when he moves the internal blocks, internal bricks, to replace exterior bricks that needed to be replaced, and he's given being able to do. Added a damp proof course. Another example of that in 2008, paragraph 8. Paragraph 9, 2009, a roof was damaged again. His own repairs with his slates. Paragraph 10, by 2010 he arranged door and window openings, 4 to 5 lines down, some with fenestration, some not. And then 2013, about halfway down, started using inner dividing wall bricks, block walls in their stead, sandblasted some of the brickwork. And he had more time from 2015. And then he really starts to think he's going to replace the original roof trusses because they weren't safe. So he explains what he did. The old woodwork, 125 years old. Some had been open to the weather before he started his work in 2000, and he finished in 2016 to 17. Paragraph 11, completed the work by 2010, but none required any wall to be demolished. We made points about that, comparing the situation with other cases in which the walls did come down. He's made a point about the way that the bricks can look. Bottom of paragraph 11, 2 large openings they've made to get vehicles in the remodel to match the originals in 2016. So that's after the relevant date, but my submission not so much as to mean that there hadn't been substantial completion of the new building. And then his opinion from paragraph 12, there's not a new building anyway, but we're not concerned with that in this appeal.
Right, so this statement which Mr. Devine made in June 2020 was before the inspector?
Yes, it was. Yes, it was, my lord. It was sort of incorporated in his very short proof of evidence, which was obviously put in much closer to the inquiry dates in July 2021.
And Mr. Devine gave evidence?
He gave evidence, yes.
At the inquiry?
Yes.
That evidence was affirmed?
Yes.
When given?
It was.
And there was some questioning of Mr. Devine, was there?
Yes, that's right, my lord. He was cross-examined at some length. He gave his evidence in chief by taking the inspector around on a sort of guided site visit, because he explained that his memory concerns were such that he didn't feel confident to relay it in an inquiry venue. So everybody went on site and sort of pointed out what he'd done.
But there was questioning after that, was there?
Yes, we went back to the inquiry venue, and then cross-examination took place. And
right.
I can't recall re-examination. I suspect there was probably a little bit.
Yes, yes. Yes, well, that makes that clear. Thank you. Right.
What he did do in an attempt to assist the inspector was to produce a plan and these handwritten pages, which is a section I, which runs from page 160 in the supplementary bundle.
Yeah.
So if we go to page 162, he's got a plan of the existing situation. He's marked on that in red, as far as he could, what he had done and when. That might just help to bring it to life a little bit for the court. So he put X's where he had, he's explained, areas where work was done, reinstated openings or alterations prior to 2010.
So this was drawn by Mr. Devine himself?
Yes, it was. It was prepared by the appellant.
And was before the inspector?
And this was before the inspector.
Yeah.
Yes. So you can see what he's done and with the dates added. So it's just the roof in respect to which the work was done, 2015 to 2017. Large
Right.
part is done for that. And then the schedule of works appears at page 163 onwards, 3 pages.
And that was also before the inspector?
And that was before the inspector as well, yes. I don't believe there's anything here that wasn't before the inspector.
No. Right.
So he's just tried to list there. So one, it's semi-derelict state of repair in June 2000, roof repaired in all areas countless times and decided to renew it all in 2015, 2017. 3 areas of brickwork, too numerous for him to recall. Damp-proof clause, failed concrete lintels, 2001 to 2010. I mean, the court can see the dates.
Right. He put it. Item 9 is porch that was.
Yes, he did. He added a porch. That was taken down.
And did he explain what the purpose of the porch was at any stage?
I don't think he did. Let me just check that. So I don't mislead the court.
Then he subsequently took the porch down.
I don't think he has detail that. There wasn't any particular focus on that.
No, was that in his statement?
It doesn't seem to be in his statement or his
No.
his proof.
Right.
Anyway, that has gone.
Mm-hmm. Yeah.
So essentially, all the dates are before the relevant date, apart from, of course, the roof.
Right.
And it should be remembered that the council did accept they didn't have any evidence to counter the appellant's evidence up until 2018. So I'm not sure that's been quite carried through into the logic of the interested parties' submissions or the inspector's decision. Of course, the inspector's free to make his own judgment. I accept that. But the local authority did make that important concession.
Right.
Because they hadn't visited before 2018. Might be helpful also for the court just to touch on the aerial photographs.
Mm-hmm.
Those require going back to page 110.
Yeah.
So I listed it there later on, but I've got to look at these photographs anyway. So So, page 110. So this is from 2017. And over the page 2018, and then the court's probably already seen this, but there's a series of photographs that were just taken out because there were a great deal of photographs and expand the size of the bundle.
So what do we get from looking at these photographs?
So
For
the first one,
purposes.
page 112, which is originally 49, that's just, and then Mr. Devine explained on the page following each time what it was that we were looking at. So
Right.
page 112 explained at page 113. Roof in 2000 as left by council after years of neglect and lack of investments and repairs in 2001. So we don't need to worry about the comments that he makes, it's just simply that's what it is. So
Right, so
that's what we start on.
The first one is 2000 and
2000, as it was at 2000.
is that right?
Page 112.
Oh, sorry, I was looking at 110.
Photograph 49 at page 112
Yeah,
is the roof as it was when Mr. Devine bought the building.
yeah,
And then if we go to page 114,
yeah,
he's got a before and after of that area. And I'm forced to note that the shape is the same, but it's been restored on my case. So 2004 to 5, showing existence of the building, and then the explanation for photograph 60, the after, is as it was in 2017 after repairs to brickwork, repointing and sandblasting and brick chemical cleaning. Now the photograph is in 2017, he's not saying that he did the work in 2017,
no,
it's just given an accurate date. Page 116, photograph 71. This is from 2000, showing he calls the cow channels in floor, overlaid with new concrete and new damp-proof course installed, existing floor still in place, all metal work removed. At 2000 there was no damp-proof course present. And then photograph 72 on page 118. He's put in to show the condition of the roof timbers at the start. Some temporary repair in 2003 and then more repairs in 2010 due to storm damage. I think he said 2009 in his statement. I don't think much turns on that, but that's the general time which took place. Point being before 2015. And then photograph 76, page 120, again, that's the condition of the roof. And he says numerous repairs done in the intervening years, just not the wholesale one. And then the last two, page 122, again we've got it before and after. This is the brick refurbishing that he did, and just replacing damaged bricks, cleaning and sandblasting. Some minor changes to the openings, but no increase in their volume.
right. And the do we have a picture of the porch?
No, my lord. I don't recall whether there was one. There might have been.
Which door was it that the porch was constructed on or around?
I can't say without being potentially misleading, but I can certainly check that point.
No, well, it doesn't matter. I just wondered whether it was the door that one sees in the picture on page 122 at the top.
I think it may have been, but again, I don't want to mislead. I can't.
No,
say
quite,
for sure.
of course. Thank you.
And the last photograph, page 124. That shows the former owner's alteration to the brickwork, reducing opening size as lintel shows.
Yeah.
Reinstated around 2002. So those are really just to give the court a flavour and to highlight, I suppose, the dates all being before 2015.
And just in these pictures, in the after condition, as it were, Where are the points of access inside the building?
So, for example, on page 122, my lord,
Yes, the door.
and the after. So the after is the top picture. The
Yeah,
door.
and that would be the principal entrance into the building, would it? Is that
There's
in the
giving
before?
evidence, really, but
Yeah, in the before picture we see there was a sliding door on the end elevation and
yes.
and a larger opening on the upper elevation on the upper floor,
So that's
which had been changed. Let's use a neutral word to the arrangement one sees in the after shot at the top on page 122.
Yes.
So I was asking that made me ask. What were the openings into the interior of the building so that one could gain access to it? And are you telling the court that you think that was the door that we see in the top picture on page 122?
Okay, so I was just orientating myself. So east. So this will be the north. We're looking at the north elevation. So as I recall.
Yes, not the gable end, but the flank elevation.
Yes. So that we on the site visit we I think we went into this door, the west entrance, but there was also a way in through the south. And I recall that's the way that we got into the building.
Right.
But this is not the only entrance. There are two. Quite a large opening towards the south, or at the southern end of the western elevation. It's not shown in this
Facing south.
photograph. Yes.
Yeah.
Just comparing, if we may, the two photographs on page 122.
Yes, my lord.
I just want to be clear, because I may not have followed this correctly. The door or entrance we see in the top photograph, was that new?
Yes, he's saying that he changed that.
Yes.
Yes, so he says on his explanation page, on page 123, this changes to opening. Let's go back to his statement.
Was there any evidence at the inquiry as to why he inserted that new door?
I don't think so. I'm just loath to say yes or no because
No.
it might not be true. It
No,
might have been a question.
That's fair.
On it. But I know that his general case was that he had some of the openings had been bricked up, so he opened them again, and he bricked up some of them, and he was just sort of moving them around. I don't think there was a particular purpose other than he needed to be able to get in. So I suspect it was his personal preference to come in that way. But I think going beyond that, I might be making things up. So I don't want to risk doing that.
The difficulty which the inspector perhaps faced was that on the face of it, this doesn't look like simply repairing things, for example. To some extent, at least, the inspector may have been entitled to think, well, there are some new features being put in here. Would that be fair?
Well, certainly the east extension is completely new.
Yes.
But the inspectors decided it according to the fact that the materials used are new, because there's a whole section, or short section, on whether the roof slates. I'm sorry, I don't have the same background as the appellant, but the appellant had said initially, he sort of reused them, but when he had, he said, no, I haven't. I did bring some on site, and the inspector used that in his reasoning. Said, well, that's that. Then this is all new. They focused on the fabric, but
no, I appreciate that. But if we just take, say, for example, those elements which the appellant himself was putting forward as being post 2015, like the porch, which I think he said was in 2016.
that's right, my lord. Yes, but he
Later
demolished it anyway. So I'm not sure that it's.
I'm sorry.
He demolished it anyway.
Yeah, well, fine, but was the inspector entitled to take into account the fact that on the appellant's own case, in 2016, in other words, after the relevant date for time limit purposes, there was added a porch?
I think if it had remained, then that would go to the character and purpose of the building and its design and layout. So potentially yes, or simply yes.
Right. Okay.
But the fact that it had been demolished means that it's not relevant.
Well, perhaps, but was the inspector entitled to take it into account in the overall assessment that the new building, which he found to be in place, had not been substantially completed by March 2015? Is that something that, for example, the building of the porch, was that something he could take into account in arriving at that overall assessment?
I certainly wouldn't say that it should be left out of account, but whether it would have any weight's a matter for the decision maker, of course, but whether it would have any weight, then I mean, particularly given that it had all the facts being demolished, then so whether that would go to substantial completion, it wouldn't mean that it wasn't substantially completed because it's not necessary for substantial completion. It's an adornment, really.
Right. Yes.
I think the inspector it might have referred to the porch. I don't recall.
46.
Yes, that's right. Yes, except for a porch since removed, and the insertion of doors and windows, the drawings show the building as it is now.
Sorry, which paragraph is it?
26.
26.
So
Sorry.
he's noted that the door has been removed.
Yeah, that refers to the porch.
We don't complain that he's mentioned that is part of the facts. But if the question is the character and purpose of the building, and one doesn't look at what one presumes the intention to have been, then it's not material.
But he does refer to the porch, doesn't he, in the context of the repurposing of the building in paragraph 26?
Yes.
Yeah.
Yes, he does.
Yeah.
So it's within that impermissible reference to intention,
Right.
and the looking at the situation through the assumption that this was a partially completed residence.
If indeed it was an impermissible reference to intention.
If indeed it was, I mean,
As opposed to purpose.
Of the building.
Oh. Well, the difficulty is that he does use the word intention over and again, and the House of Lords were astute to distinguish between the two. I do see, my lord, that there's an overlapping, I suppose, in terms of intention to come into purpose.
Well, obviously we must read the decision letter carefully as a whole. That's common ground, I'm sure.
Yes.
And we shall do that again. But to be clear, we understand your submission is that 25 and 26 both refer to intention rather than purpose.
Yes.
Is what you submit.
Yes, and I decision myself as an officer of the court, not just as
Of course.
a representative of the appellant. And in my submission, a fair reading of the decision letter as a whole is that the inspector has focused on intention and hasn't looked adequately or at all at design layout purpose. In other words, the objective. What does this building look like? And that's brings me conveniently to the aerial photographs,
Right.
which of course aren't determinative, and perhaps never are, but they're from page 137.
Yeah.
So we see, first of all, this is 2005. So I invite the court really just to take a broad look at the shape of the building. Of course, it was extended to make the U shape, but you can see a sort of kink in the roof where the line isn't quite straight, and that remains throughout. So it's the same building, the same footprint, same design.
So what was the date of 137?
137. We've got the
The 1st of January 2005, is that right?
Yes, my lord. And then 2009 on page 138.
You say the kink in the roof.
Yes,
It's the either a failing in the member that supported the ridge of the roof, or some other quirk of construction that produced that kink. We don't know, but I mean that would be consistent with there being a slight kink in the roof seen from above.
I mean, I'm not qualified to comment, my lords, but it was more to make the point that hasn't changed.
No, that point we've noted.
2010, page 139, and then page 140, 2017.
Yeah. I mean, to the naked eye, it looks slightly straighter in 139. But anyway, we're not finding facts. We're looking at photographs.
But I respectfully agree, my lord. It does look slightly straighter at that point.
All right.
Yes, so 2018, 2019. So the court has an aerial view.
I mean, it's not in dispute, as a matter of fact, that the roof that is on the building today was put on the building after the relevant date. That's not in dispute as a fact.
Not in
No.
Yes, but the appellant he didn't try to pretend that he'd done it before.
No. That's understood.
Well, I think without labouring the matter further, I may have come to a convenient end. I'll just check to see whether I've made all the points I wanted to draw out.
Can I just ask you, Ms. Holly, the point you've emphasised before this court, that the inspector fell into error by impermissibly taking into account the appellant's intention, was that a point that you advanced before Mr. Justice Fordham?
No, I don't think it was to the same extent, my lord. No, I think I focused on other points. It's a point that's evolved in the context of the case.
Yeah. And again, I don't say this by way of criticism. But can I just be sure what the grounds of appeal are before this court? Have I got the right document if I go to the core bundle at page 31? There appears to be only one numbered ground. Is that right?
Yes, it's put globally.
Yeah. And just finally, on this line of inquiry, if I may, did Mr. Justice Fordham deal with the intention point at all in his judgment? He may not have done if he wasn't really asked to, but I just...
Well, he did.
Right.
He referred to a relevant passage in Sage at paragraph 6 of his judgment.
Right.
Right. Should we look at that?
That's page 63 of the Corbun.
Sorry, paragraph.
Paragraph 6, page 63.
Yeah.
Yeah.
I'm sorry if I said paragraph.
That's very helpful.
Both counsel emphasise the authoritative wisdom expressed in this passage from the speech of Lord Hobhouse, with whom the rest of the court agreed, which is paragraph 14. The inspector rightly did not investigate the intentions of Mr. Sage at various stages in the history, nor the uses he'd made of the structure from time to time. The character and purpose of the structure falls to be assessed by examining its physical and design features.
Yes, and he deliberately reminds himself in the plain text that follows the quotation from Lord Hobhouse's speech.
That character and purpose to be assessed by reference to physical and design features objectively and not through an investigation of subjective intentions.
So the judge has directed himself correctly on the law at that point in his judgment.
Yes. He has. Our complaint about the judgment lies in summarise it helpfully.
If there's a passage in your skeleton argument that does that work, please do draw it to our attention.
Thank you, my lord. Despite having directed himself correctly, there's reliance nonetheless on the intention that the inspector referred to.
Where is that in your skeleton?
That's paragraph 29
Yeah.
of the judgment.
Oh, the judgment. Sorry, I thought you were looking at your skeleton. Yeah, the judgment is 29.
Yes. 28 and 29.
28 and 29.
So at top of paragraph 28, the learned judge says the inspector did not investigate the intentions of the appellant at various stages in the history, but in my submission he clearly did.
What does he say about paragraph 26 of the letter?
That again in paragraph 28, 8 or so lines down, the inspector had earlier, paragraph 26, explained that he had regard to floor plans and drawings from the 2018 planning applications. His observation would be a substantial leap of imagination to view this repurposing as an unplanned consequence. He said that was an objectively based evaluation derived from materials from which he concluded that the structural or elevational changes deemed necessary had already been carried out by 2018.
Mm-hmm.
But when one looks at the actual text of the decision letter, the fair reading of my submissions, that he certainly was looking at intention. He said so, and that's the only way in which the decision letter can be read.
Despite the word repurposing.
I think he finds it to have been repurposed because he's focused on the appellant's intentions. That's the only way that he can find that. He found it to have been repurposed because, to be a little bit extreme about it, it had been razed to the ground and something that looked unmistakably like a dwelling house was partially in its place, then one could say objectively it had been repurposed. But in order to find that it's been repurposed, he's taking into account the aspiration expressed on the planning applications.
Just a little bit later on, in paragraph 28 of his judgment, the judge again returns to this contrast between subjective intention and objective purpose when he refers to paragraph 40 of the decision letter.
Yes.
5 planning applications, the quote intention as at 2018, but he says he had earlier described that as an intention that the building should become a dwelling, but these were an assessment of character and purpose of the structure by examining physical and design features, expressly directing himself again to paragraph 14 of Sage.
He does one odd. He says that, but in my respectful submission, that's how the judge intellectually squares the circle, because he's directed himself correctly that one doesn't look at intention, one looks at character and purpose according to physical and design features. So he's simply stated that that's what the inspector was doing. But when one goes to the decision, we respectfully disagree with the learned judge. That's not in fact what's happened. So the focus of our criticism of the learned judge's approach is really, I suppose, the key point that the judge says that a key part of the construction of the building was the roof, and that wasn't there in time. And so we say, well, one has to look at it in the context of what it means to repair a building over time, and the fact that this was already a completed building has to be seen in that context, and not as in, for example, Sage, where there wasn't anything there previously, so it would seem we've only ever had a partially constructed building.
That's, you say, Sage.
Just drawing a contrast with Sage for convenience.
Yeah, because in Sage you said one only ever had a partially constructed building.
Unless I'm reading the facts incorrectly, yes, it was a partially constructed dwelling, whereas here we had a completely completed building that was then repaired.
Well, I know that was your submission, and that remains your submission, but the judge squarely addresses that at paragraph 29 and rejects it. He says, it is clear from the inspector's reasoning that he did think this was an unfinished dwelling. And then,
yes.
and then the rest of paragraph 29 consists of the judge's analysis of why the inspector was entitled to reach that conclusion on the evidence, and he finds there's no public law error in reasoning. And at the very end of paragraph 29, in my judgment, the inspector was faithfully considering character and purpose of the structure, assessed by an examination of physical and design features, again cross-referring to Sage paragraph 14. I know you don't accept any of that, but you say that's all wrong in law.
Yes, there's no failure in the judgment of internal logic. There's no internal inconsistency, but it's the starting point, which, so one reads it and it all looks free of error, but the judge isn't. Well, we'll be careful what I say. The inspector proceeded from an assumption that he was looking at a dwelling, and the judge hasn't stood back and examined that. He's taken the same approach.
I see.
So that's the problem, and that's why the allegedly fatal errors in paragraph 30 aren't fatal in my submission. The first one, well, I've detailed why the absence of further repair of the roof before 2015 doesn't matter on the facts. And then the second allegedly fatal error is the sort of residential occupation point. If I could put my case in a nutshell, it's that only follows if you proceed from the assumption, but that's what he was doing.
Yes.
It might seem strange at this point in the proceedings for me to suggest that we might look at the enforcement notice, which hasn't so far featured in our proceedings this morning. Where do we find
I'm
that?
sure that we've actually got it.
No, I don't remember seeing it. Actually.
Concerning, but it's
Is it quoted somewhere?
described in the appeal decision at page 118.
Yeah.
Right. We just take a moment to look at that. The breach. This is the fourth bullet point in the inspector's summary at the beginning,
Yes.
which is on page 118. The breach of planning control as alleged in the notice is, without planning permission, the erection of a new building and the erection of a boundary wall and fence. So the allegation was not that it was a new dwelling house. It was that it was a new building.
Exactly, my lord. Yes, but we've highlighted that point.
Yeah, and the inspector finds that it was indeed the erection of a new building. That's what he holds in terms.
Yes, he finds it's a new building.
Yeah.
But
And that is the substance of the ground B appeal,
yes, which we can't
challenge.
challenge.
So that which you can't challenge goes to the main substance of the enforcement notice.
Yes. In which
So
case,
the true, I think this is common ground actually. The true range and scope of the appeal, as in the court below, the appeal there, the 289 appeal, is as to the time at which the new building became or didn't a new building.
yes, my lord. So it's not what happened, which is ground B. It's when it happened, which is.
But again,
ground
it's
B.
you're attacking a conclusion based on findings of fact, which you don't attack, as you've made clear. You don't attack the findings of fact. You attack the conclusion,
Yes, the interpretation of them, I suppose. Yes, I don't.
which is a matter of planning judgment.
Well, we would say that ground B is clearly planning judgment because of the matter of fact and degree test, but ground D has to be more objective.
Yeah.
It's not planning judgment.
It's objective. Well, it's findings of fact principally,
Yes.
which are not attacked.
Well, no, but the problem is that the inspector extrapolates from them and brings into account intention.
Well, you say that the inspector has brought into account matters which ought not to have been brought into account, namely the two things you mentioned, intention and the whole conception that it was, or the initial and prevalent conception in the inspector's mind that this was all about building a dwelling house.
Yes.
And those are the two things that you say vitiate the assessment overall relating to ground D.
Yes. So it doesn't matter that I accept the findings of fact, but it's what one does with them. So no, we don't say that the inspector got something wrong or described it incorrectly.
But have I fairly encapsulated the nature of the appeal in those short observations?
Lord, I believe you have. Yes. So ground B is a question of planning judgment. It's all about what was done, and in any event we can't attack that today, or indeed we couldn't in the court below. Ground D is about when that was done. And I say that's not. It might be, but it's not a matter of planning judgment. Certainly in this case.
So when we look at, if I'm being slow, forgive me. It may very well be that I am. When we look at what he actually says about that which is in contention in this appeal, which is the Ground D appeal, which is from paragraphs 37 to 43, where do you say those two extraneous matters intrude?
So straight away in paragraph 38. So.
Does he refer to intention there?
He does at 39.
Yes,
yeah.
I'm grateful for that model, and also at 40. I think it's 26, 28, and then 39 and
so evidence,
40.
39 says evidence of the appellant's intentions for the building at that time was not presented. And then 40?
At the bottom, that intention was repeatedly stated in the 5 applications made in 2018.
Yeah. So you rely on those two passages?
Yes. And I mean, it doesn't say at paragraph 38, I'm looking for a dwelling. I mean, it can't say that, but it's obvious that that's why we use the term, is looking at it through that lens, through that starting assumption. And
the fifth line in paragraph 40 does say, consistent with an objective of creating a building suitable for residential use.
Well,
I think that's a point in your favour.
Yes, why not?
The inspector does seem to be identifying that there was an objective of a residential building.
Yes, my lord. I mean, I would. This whole paragraph is shot through with that starting.
And I'm not necessarily saying that I agree with you.
I understand.
But I'm just trying to understand what the inspector is saying. It might be said that when he uses the word objective in that line, that read in context, he immediately then uses the word intention in the next sentence. He says that intention was repeatedly stated in the 5 applications.
Yes, so...
And you say that's an impermissible factor to take into account because Sage says that the developer's intentions are irrelevant.
Yes, my lord, that's what I say. Yes, so when using the word objective there, he's really talking about intention. In my submission, he just used a different word. And he wouldn't have started off by talking about a lack of heating and sanitation and doors and windows being included if he wasn't judging it against the standard of a dwelling house. So the enforcement notice says erection of a new building, or well, it's been found against us that it was a new building, but the Ground D is still available to the appellant. Well, has it nonetheless been done too long ago for it to be enforced against? Well, yes, and also factor in that there's a continual process, all of the time, of these repairs and restorations. Yeah. But the inspector correctly at paragraph 37 mentions the substantial completion test, but of course substantial completion of a dwelling house is going to be different to substantial completion of a barn.
Yes, it may help you as well to look at the middle of paragraph 41, that by 2018 any structural and elevational changes that the appellant deemed necessary for future residential use
that have been carried out. Yes. So
again, I'm not saying I agree with you, but to understand your submission, I think you would say that there again the inspector is impermissibly focusing on 2 things. 1, the appellant's intentions, and 2, that those intentions were to have a future residential building.
Yes, my lord. I've had to put it more globally, and I know I've highlighted certain passages, but yes, I mean, this entire section proceeds from an assumption that the inspector is judging whether a dwelling has been substantially completed or not. So it's not surprising that he's found that it wasn't. I mean, the appellant would entirely agree there's no substantially completed dwelling, because, well, that brings in his own intention into account, doesn't it, to say that he wasn't trying to do that. But to looking at it objectively, I mean, it's not.
Can I ask you this, Masoli? On the appellant's case, how would you describe the new building? What was because the inspector found there was a new building.
Yes.
But what would you say that new building was?
It's still an agricultural building.
Can I just bring us back to paragraph 37?
My lord.
We haven't actually, I think, looked at that paragraph closely yet. But the question I wanted to ask you was whether the test stated for the inspector, stated for himself by the inspector, is a correct legal test.
I believe so, my lord. Yes, he says that were the building operations
So
substantially completed.
he's asked himself the right question.
Yes, I don't think we can have any complaints about the text of that paragraph. It's the building, but it then becomes clear after that that he's talking about a building that he's decided as a partially constructed dwelling.
Yes, but that, of course, we have to read together with what's gone before in the treatment of ground D.
Of grounds B.
Ground B, forgive me.
Yes.
Yeah. And he answers the question, ultimately, doesn't he? In 42.
The ultimate answer, of course, my lord.
42 and 43, yes.
Sorry.
I'm sorry?
No, I apologise.
I didn't hear what you said.
Is it the answer to the ultimate question of the universe being in 42? That's a Hitchhiker's Guide to the Galaxy.
Oh yes, no, I think I may have read it once.
I'm sorry. Yes, 42. The building works that resulted in the northern and western wings becoming a new building were not substantially completed on or before the relevant date. As a matter of fact and degree, considering the changes made to it from 2015 onward, the east, and he goes on to talk about the eastern wing. So it's a simple statement.
But anyway, you invite us to say that en route to that conclusion, the inspector has wrongly had regard to the two things that you've highlighted.
Yes. Yes.
And that's clear. That's your submission. And that is clearly your submission.
Yes. I mean, reading the letter as a whole, as one has to. Looking at the ground B section, the inspector focuses, of course, on fabric and how much of the old material has been reused to come to his conclusion. But what we don't see in that, if we looked in that to see some sort of explanation, regardless for why he's saying that, according to design and layout, character and purpose, it's become a dwelling. We don't see that because we don't see anything in that body of reasoning that shows that the footprint's changed or that there's been any changes, really, any significant changes beyond the material. It's the materials that have changed. So in my submission, there's nothing really in that that goes to, on an objective view, changing the purpose. It's found that the original base is there, paragraph 31. That the walls are the same. He's tried to reuse the bricks, he just wasn't able to completely, so he had to put in. But there's no change in design, I suppose, is what I'm trying to say.
Right. Well, that was a matter for the inspector, wasn't it?
It's a matter for the inspector, yes, which is why that can't be challenged. That was his planning judgment on the outcome of ground B. But if one looks, ground B nonetheless is useful. If I was trying to be benevolent to the inspector and explain his ground D decision, other than by concluding that he's looked at it from the wrong starting assumption, if you go back to ground B and look at the findings of fact that he's made. So he's saying this has been done, this has been done. None of that adds up to a change in design and change in layout, such as might nonetheless have led him to conclude, despite the absence of reasoning, that this was a change meaning that the building now had to be judged according to a different standard. Because it can only be said in my submission that the new building is not substantially completed if one is looking for a dwelling. That's a key point. If one's looking for a barn, one can't say that it's not substantially completed. It's just simply had the roof repaired. Looking for a dwelling, then yes, it all makes sense.
Yes. Well, we don't need to retread the ground that's well trodden already. We must look at the decision letter as a whole, not just the isolated paragraphs that form the focus of the appeal. But that's common ground.
But that's why I've tried to look at it benevolently.
Of course.
By taking into account, are there any findings earlier in the letter, or in the letter as a whole, which would nonetheless allow the inspector to come to the overall outcome that he has, despite, in my submission, going wrong by taking into account intention and deciding that it's a dwelling that he's looking for, which doesn't fit the evidence because he hasn't considered any other possibility, which would explain the planning applications, for example. He's just gone into an intention.
Right.
I think I've taken enough of the court's time. I'm grateful.
You've said everything you want to say to us.
I think I have, my lord.
Right. Thank you very much, Miss Ollie. Thank you very much. Yes, Mr. Humphreys.
Yes, good afternoon, my lords and my lady. Perhaps it won't surprise you to know that I say that the judge was right for the reasons he gave, and I won't claim to be able to particularly improve on them. He sets out his position very concisely and sets out, importantly, two clear reasons why he found the appellant's challenge was flawed. And if I could just make a preliminary observation in relation to that. The way the judge resolved the matter, and I endorse, is that he found there were two separate reasons which stand independently why the challenge brought by my learned friend on behalf of the appellant can't succeed. The one is the roof point, because the roof was integral to the creation of the new building, and that wasn't done until after the relevant date in 2015. In essence, the challenge stops there. And there was then a separate reason, which was also entirely lawfully correct, which was, if I call it, the intention point, to use my learned friend's language, and the judge found, obviously, as your lordships and my lady have discussed with my learned friend, that was an approach in accordance with SAGE when one properly considers what the inspector did in the decision letter. I propose to address you on three broad issues. The first being, albeit something that's not really been touched on in oral argument today, the actual reason permission was granted on the papers, which is on the basis that planning enforcement action should not be punitive, it should be restorative. And it's a point that is addressed at some length in my learned friend's skeleton argument as well. And in a nutshell, in relation to that, I say there is no punitive action taken when one properly considers what the breach of planning control that was alleged was, which was the creation of a new building, not the removal of a 125-year-old building. It was the removal of a new building. And as we know, and as we've already discussed, the inspector found that there was a new building. And the second main issue would be the concept of roof workers repair. And so something, pardon me, so something that, despite the fact that it happened after the 4-year period, doesn't matter. So that's Mr. Justice Fordham's first fatal issue. And I say no error of law arises in relation to that when one properly understands that the new building that was found to exist by the inspector was found to be a new building in part because of the roof work that occurred after 2015. And so if that is right, then there is no error of law. And finally, the third issue is the consideration of intention, and the particular references that are made by my learned friend to the decision letter. My submission all stem from the inspector's findings, and that there were plans that had been submitted for conversion works to take the previous building into So when the inspector talks about intention, he's not doing that in a what's in the head of the appellant perspective. It's, well, there's an actual design for a dwelling in this location, and he forms a conclusion in relation to that.
Can I ask you, Mr. Humphreys, the same question I asked Miss Holly? That on your submission, how would you describe what the new building was?
As found by the inspector?
Yes.
Well, in my submission, the inspector does it in two ways. His conclusion at the end of his section where he deals with section the Ground B appeal, well, perhaps if I just make this good, point this good immediately, and I think this is one of the passages that was taken from my learned friend in discussion. We looked at paragraph 26 of the decision letter. Which I submit is, in essence, the nutshell point I've just made, that what the inspector's doing is making a finding in relation to plans and elevation drawings rather than some sort of theoretical intention that he's putting on the appellant. What's important, if we look at then the next paragraph, it starts by saying, however, it is necessary to determine whether, and if so, and to what extent, the original building has survived, or whether what the appellant describes as repair and improvement has resulted in a new building. It is the building that existed when the notice was issued, taking account of the cumulative effect of the work since 2000 that must be considered. So what the inspector's doing there is putting to one side an intention point, if I call it that, and just focusing on the building itself. Then at the end of his Ground B, he concludes there is a new building.
Yeah, but what is that new building?
And yes, so what he then goes on to do at Ground D is just look at it through the lens of both as being a new building without describing a particular purpose to it, but then also looks at it through the lens of, well, the information I have before me, I've made a planning judgment that this is a substantially incomplete dwelling. So he does both.
Yeah, but do you say, therefore, that what the inspector found was that this was an incomplete residential building?
I say he does two things. So he finds that, but what he also finds is that it's just a substantially incomplete building, however one looks at it.
I see.
So that's why, even if I would submit in due course that even if my learned friend is right in relation to the intention point, and that there's been an unlawful factoring in of that in the inspector's reasoning, it doesn't undermine the overall conclusions of the inspector, because he still concludes that it's just it's not a substantially complete building, regardless of its use or purpose.
But if it's only an agricultural building, which is what Miss Holly submits, it has always been, then it may be said that it's more difficult to say it's a new building.
The problem with that, which I think my learned friend has acknowledged, is the conclusions under Ground B are not open to challenge in this court, as the commission was never granted on that. So we have to proceed on the basis that there is a new building.
Yeah. So what this really leads to is just the submission you just made is that even if you don't accept this, but even if the inspector fell into error, for example, at paragraphs 39 to 41,
yes,
in referring impermissibly to intention, even if that's right, you submit that this appeal cannot succeed because of the new building point.
But quite my lord, which is the basis upon which Mr. Justice Fordham in the court below reached his conclusion as well. He treated those two matters as separate and independently fatal to the challenge brought by the appellant.
Yes. Thank you.
And for the reasons he gave, I maintain that. And if I may, before delving into submissions, just deal with a few factual points, because they're ones that I think then feed into findings made by the inspector in the decision letter. If we could take up, please, a supplementary bundle and find, first of all, page 69. And so this is the proof of evidence prepared by the planning officer from the council who dealt with the Ground B and D appeal. So the way the council's evidence was split, was one who dealt with Ground B and D, and second officer who dealt with the ground aid. And I'm simply taking them in order. These points appear in the bundle for ease of following it through. If we just look at 5.10, there's details provided there of a site inspection taken in light of one of the 2018 applications, and that inspection took place on the 20th of March. And what the council's witness noted was, beginning the second line, at the time the appellant stated that building works in relation to the conversion had not begun. However, photographs that were submitted with the application appear to show that internal blockwork, new trusses, roof lining and steel beams had been installed. The Google imagery from 2017 and April 2018 clearly show that the roof has been replaced, as there is no variation in materials or areas that can be identified in previous alterations. It was further observed during the June 2018 site visit that the roof comprised new wooden trusses, new insulation, new battens, new steels and slate. I simply just highlight that to make the point that the point the council were taking in evidence was that, well, obviously they were disputing the factual account given by the appellant, but also were highlighting, and then this is the point the inspector takes in due course, that works described in the applications that had been made were taking place on the site. If we go then next, please, to page 75, or rather page 78 of the supplementary bundle.
Sorry, just if I can ask you to pause for a second.
Yes, of course.
The applications, we don't have the applications for planning permission, I don't think, in the bundle.
No, what I was going to take my lord and my lady to was the planning history that we have, and then we also have the core documents list, which lists what the inspector had and sets out, for example, proposed elevation plans. And
yes, but they were applications for planning permission for operational development, not change of use, merely.
So if we look, my lord, that's the next page reference I was taking. If we look at page 78, which is where we have the planning history.
Right.
So this is, like I say, contained in that proof of evidence prepared by the council's witness who deals with the ground A matter. At paragraph 2.3, we have the planning history.
Yeah.
And the first three of those applications.
Sorry, but we're in here, the document we're in is Miss Parker's proof.
Yes.
Yeah, right. So this is the planning history she sets out at 2.3.
Yes. And the first three of those applications are for conversion of barn to dwelling.
Yeah.
Whereas then the later was simply change of use. So obviously the first three incorporate works, operational development, as well as simply a change of use. And just to simply confirm what the inspector had, if we were to skip ahead to page 187.
So the description of development given in these applications referred to a former barn and a redundant barn. And these were applications being made in 2018.
Yes.
And were they expressed to be retrospective in any respect?
I've separately seen the documents. We don't have them before the court. I'd have to go back and check, to be honest, my lord. My gut reaction say there was an element of retrospective, but I wouldn't want to commit to a position, to be perfectly honest. I don't know. I obviously wasn't involved in the appeal before the inspector, so I don't have the familiarity with the background in the same way.
Understood.
But the point I simply make is they were for operational development as well as a change of use. And obviously, my lord has the point about what the description of the existing building is that's said to exist at the time as well. But just to add some detail to that, we have the list of documents that was before the inspector, which begins at page 185 of the supplementary bundle, and 187 onwards is the detail of those planning applications. So the inspector had full documentation associated with those applications.
I'm sorry, which page did you say?
187, my lord.
Thank you.
Yes.
And just to pick the first one in the list by way of example, 13.1, the first two items there are proposed and existing plans, so that there's a change clearly, and in what's been applied for. There's work, hence the different plans. And I'll pick it up when we go back to the decision letter, but I take the court to those references to make good the point that the inspector had the material before him on which he could form judgments about not simply a theoretical intention of the appellant, but physical works that were being proposed to achieve a dwelling on the site. Whilst we're in the supplementary bundle, just to take the court to some further information in terms of timing and the nature of work taken out to the roof, which is obviously one of the core points before us today. If I could take the court, please, to page 97 of the supplementary bundle. Which would be a very short letter from a company called GP Roofing and Building Surfaces.
Yeah. I noticed that we've got a drawing on page 161, but I will perhaps come to that. 97.
Yes, so this is simply a letter from the company who undertook for the appellant the changes of work to the roof in 2017, which is confirmed in the first line, and says, Barry, if you recall, the damage to the roof was extensive and agreed that a repair wasn't the correct way to solve the issues. We agreed to supply and fit all battens and slates to ensure the roof was, once again, watertight. So that's one of the pieces of the evidential puzzle that was before the inspector in relation to the roofing issue. If we go then to one...
Sorry, I'm not sure I follow where that takes us. So, if I have my house and a roofing expert comes along and tells me, well, I'm sorry, repair isn't going to be the correct way to resolve your rain ingress problem, so I'm going to put a new roof in for you. Does that mean that there's a new dwelling?
No, all of that would be a matter for planning judgment for the inspector, and he has to factor in the totality of the evidence before him and form a view on what has happened. I simply take the court to that letter. I was going to do one of the other statute decks, because we simply looked at so far one picture created by the appellant himself as to what had happened and when it happened. But there was a dispute about that, and part of the inspector's conclusions were, well, actually, if you look at evidence provided by the appellant through other sources, the timing is inconsistent, and he doesn't fully accept the appellant's own evidence. What he ultimately says in relation to the roof is it's a total replacement. So not simply are the brand new slates, everything is a complete replacement. And that's one of the factors he then feeds into his overall assessment of the new building. And it's not really a big point. I was simply taking the court to it to show that there wasn't just one set of evidence before the inspector. There was more, which he had to feed into his decision-making matrix. And if I just take the court, with permission, to one more piece of evidence, which would be that at page 105, which is a signed statement from a Mr. Andrew Devine, relative of the appellant. Who also provided evidence on works that took place after 2015. So 2016, if we look at it onwards, gable on south side, former pig pen, the width was increased back to the original size, and sill was removed from the window and brickwork from below back down to ground level. Exterior roof replaced with steel supports fitted and new battens with almost new slates. Source for their quality. Dad took a long time finding these. Wooden structure stuck on the end of the bars was removed that same year, revealing a gable which needed little work to form an opening. Repointing and cleaning of brick was done in 2017, maybe 2016. Again, I don't propose to do a full trawl of the evidence before these records, simply to highlight that there were multiple sources of evidence before him which detailed work that took place after 2015. And then just to complete the background to the decision, I suggest it is worth briefly looking at how the case was actually argued before the inspector as well in the submissions of the respective parties. And we have the closing submissions on behalf of the council, and the section which deals with ground D begins at page 203 of the supplementary bundle. And the way the council put its case is set out really detail in paragraph 55 and then the various subdivisions of that. And the council first highlighted that what is meant by substantially complete, its first Roman was first, if the intended use of the building is for residential purposes, then the building would have to be fit for human habitation. That's one angle of approach, and then that paragraph highlights a number of features, and obviously there's no dispute before the court today that if it was a building designed to be a dwelling, then it wasn't substantially complete. But there's a list of features that go to that. Separately, the council then says at Roman 2, second, even if planning permission were not required to perform works necessary to complete the building, it does not mean that the building is substantially complete, which is one of the points that derives from Sage. That was how Mr. Sage had argued his case, and obviously that was what the court rejected. And then third, the council states third, and most obviously, whether a building is substantially complete is a matter of fact degree. The council has produced an overwhelming amount of evidence to support its position that the building was not substantially completed before the relevant 4 years. This is supported entirely by the appellant's own evidence, as identified under ground B, that there has been significant rebuilding and reconstruction of the building within the relevant 4-year period, and then provides a list of such examples of work. But if I could just highlight, if I may, paragraph G of this section, where what the council submitted was photographs from the council site visit in 2018 at CD 14 clearly show that the building has not been substantially complete, whether for human habitation or for any other intended purpose. For example, there was no finished electricity supply or lighting. This remains the case today. So in my submission, the way the council was putting its case was saying you could have regard to it being a dwelling, and if you do, here's relevant factors which show that it's not substantially complete. But even if you have regard to it as a building, it's still not substantially complete, and here's the factors that go to that. In the discussion with my lord already, we've had some discussion about the decision letter and the way the inspector approached it, but my submission, given how it was presented to him, his distinction between the new building and the new dwelling point is a logical one and arises from the way the case was presented to him. My lord, so I draw the court's, my lord and my lady, I draw the court's attention to those points just simply to add some further factual background to how it was and what it was that was presented to the inspector. But if I move then to deal with the three broad issues that I highlighted, the first I can deal with relatively succinctly. Part of the reason permission was granted to appeal to this court was because there was a feeling that there was an unfair result which suggested that along the way something could have gone wrong. And that's the point that my learned friend makes in her skeleton argument, that the consequence of this is that a building that has been on the site for in excess of 100 years is required to be removed. Well, the way I summarised my point, case on the point earlier, I can't really advance on. The enforcement notice enforced against a new building, and the inspector found there was a new building, and so there is no unfair requirement because what's required to be removed is the new building. And just would also flag that there was no ground F appeal in this case, so it wasn't that an argument was put to the inspector that, well, less could be done to comply here. That is a statutory ground of appeal, and it just simply was never pursued. My lords, I'd move on then. My lords and my lady, I'll move on then instantly to the second broad point, which is the new building phase and Mr. Justice Orden's first of his fatal two grounds. The way the argument is put on behalf of the appellant is that there's been a legal error by the inspector because the work done to the roof was only repair, and so there must have been a substantially complete building before then, which has then simply been repaired. In my submission, that argument simply doesn't arise because of the conclusion on ground B. In reality, despite the skill of my learned friend in how she's tried to put the argument, it is ultimately a challenge to the ground B conclusion. Mr. Justice Forden, you'll note in his judgment, set out the entirety of the ground B section because my submission was correct to do so, because it is very thorough consideration by the inspector of all of the factors that lead to the conclusion that there is a new building. And at no point in that section, we'll go to it in a moment, does the inspector make any finding that there was at a previous point a building that has then simply been repaired. What he assesses is the totality of the evidence before him, forms from that conclusions as to what work was carried out, and then assesses what all of that work means for whether or not there was a new building. And in reaching his conclusion that there was a new building, he has relied on the fact of the replacement of the roof. And so the new building that he finds exists in part because of that replacement of the roof. And so that replacement work can't really be isolated from the process because it's fundamental to the finding of the new building. And my lord, and my lady, I would commend the full reasoning of that section of obviously both Mr. Justice Forden, but indeed the inspector to the court. But if I may highlight a few key points. If we go back to the decision letter and look at paragraph 20, which I have at 121 of the court bundle.
Sorry, paragraph?
Paragraph 20, my lord.
20, yes.
Beginning on page 121. Or perhaps actually, if I could actually backtrack slightly, and just go to where ground B starts at paragraph 8.
Yeah.
The way it's structured is the inspector identifies numerous elements of the building and then assesses the evidence that exists in relation to what work has taken place in relation to each of those different elements of the building. He then deals with the roof, beginning at paragraph 20. And in his second line there, finds that the structures that support the roof were replaced. The entire roof structure, incorporating new timbers and steels, were replaced during 2016 and 17. The next issue then goes on to consider is the extent to which original slate versus new slate was used, and he highlights some inconsistencies in the evidence on the point there in paragraph 21. And for example, highlighting a significant change made in cross-examination of the appellant, then draws attention to the statement of Andrew Devine, which is the one we've looked at, and before then concluding it's thus not been demonstrated that the slates placed on the roof in 2016 and 2017 were reused originals. It is more likely they were new to the site. And so he's forming a conclusion that in essence the entirety of the roof structure is new. And that is something that happens in 2016 and 17. So having identified the evidence and set out what works did take place, the inspector then asks whether these changes constitute in a new building, and there's obviously no legal challenge to the approach there. But clearly he factors in that the roof as part of the reasoning why he concludes that there was a new building. And so we see that at 28, and he highlights the roof as being one of the features he relies on in concluding that there's a new building. And this is reinforced in his 30 and 31, where he highlights that there is in essence little material of the original building remaining. And then at 32, he exercises a planning judgment to conclude, and that although the building works undertaken between 2000 and 2018 have been presented as apparently unconnected repairs and improvements, the outcome is a unified building. So that is the outcome of the works that have taken place between 2000 and 2018, therefore necessarily includes the works to the roof, which he identifies as taking place in 2016 and 17, while the northern and western wings broadly follow the form and mass of the original building. So he's taken that factor into account. They are significantly different in terms of their fabric. When the elevational changes to those wings and the construction of the entire eastern wing are also considered, there can be no doubt that a different and therefore new building now exists. What fabric remains from the original building is fully incorporated in this new building. And so when the inspector then comes to deal with ground D, his inescapable finding is that the ground D appeal fails because significant elements of the work, which he finds create the new building, have taken place after 2018. And in the ground B, he separates the intention point, as I've already submitted right at the outset, and so if I'm just looking at the building here, and he finds that the new building, whatever it is, works that create that building are still going on in 2018. And so, even without taking into account intention, he was bound to find, as he did, that the building was not substantially complete prior to the relevant date in 2015. If I may then just move on to the intention point, the final of the three issues I wish to address the court on.
Yeah.
And perhaps if I start by briefly looking at Sage and paragraph 14, it is really a relevant one for my purposes.
Right.
It should be page 36 of the appeal bundle, the authority bundle, which contains paragraph 14. And perhaps just pause to note, whilst we're at Sage, that as my learned friend highlighted, and as was highlighted in the judgment of Mr. Fordham, we agreed that paragraph 6 of Lord Holthouse's judgment didn't alter, apologies the other way around, the paragraph 6 of Lord Hope's judgment didn't tweak, doesn't change the lens. One should look at paragraph 14 of the judgment of Lord Holthouse.
Well, I think, does Lord Hope agree with, he expressly agrees with
Yes, my lord.
both the speech as a whole and the reasons given. See paragraph 2.
And nobody agrees with Lord Hope.
No, it's a case where Lord Holthouse gives the leading judgment and then others express agreement or comment upon his opinion.
Yes, so paragraph 14 in Lord Hobhouse's speech.
Yes, and so the important points to draw out of this in my submission are the line, the character and purpose of a structure falls to be assessed by examining its physical and design features. The relevance of the assessment is determined whether or not the building operates upon requiring planning permission. The actual use made of the building does not alter the answer to be given. So we get a rather colourful reference that has already been referred to. But in my submission, what the court is saying there in Sage, or rather what Lord Holthouse is saying there in Sage, is just because an individual who's done some building work says this was my intention, that doesn't mean that was the intention. What you have to look at is the actual building works that have been carried out, the design and other features of the building, and then form a view as to what what that building is.
Yeah, I mean, he expressly says physical and design features.
Yes, yes, quite. And so, without trying to use overlapping language, design has an intent. You design something in a particular way to achieve a particular result. And so, when we come to look at the language of the inspector in reference to intention, my assumption that should be taken to mean, well, what was in the mind or what was the intention of the appellant in some sort of impermissible way under Sage. That's a reference to the design. But what is the intention of a design of this nature?
Well, it may fairly be said, and I'm not in any way seeking to transgress what was held by Lord Hobhouse, it may fairly be said that usually, I'm not saying that's this case, usually intention and purpose will coincide. Because usually if I intend to build a dwelling house and I build a dwelling house, the purpose of the building will be evidently a dwelling house. They're not disjunctive. The real force of the point made perhaps is that one doesn't simply look at intention so that one has the entirely subjective view offered by an appellant, say in an enforcement case or a normal planning case. I always intended to do ... or I never intended to do ... One doesn't rely on subjectivity, one relies on a properly objective investigation of the circumstances. An application for planning permission, which may have drawings included, usually will, have drawings demonstrating the building one is intending to erect, will manifest an intention, but they'll also manifest a purpose.
Yes, which I think is hence the point made later in Sage that planning permission carries with it planning permission for the use of the building, that planning permission is sought. And yes, my Lord, I'd agree, and where that leads us to in terms of a task facing an inspector such as the inspector we're concerned with is to take an objective assessment of the evidence to say, well, what is this? It can't be determined by what the appellant himself is saying. But that doesn't mean one then excludes, for example, design intention. Well, what was this designed to do as a building? And so when we then go to the decision letter, if we may go back to that paragraph 26, which we've touched on briefly, what the inspector says there, apologies, this is page 122 of the core bundle.
Sorry, we're looking at...
Paragraph 26 of the inspector's decision letter.
Yeah.
Apologies, jumping about page 122 of the core bundle. The inspector says the elevations and floor plans from those applications are marked existing and proposed, indicating that any structural or elevational changes the appellant deemed necessary for residential use had already been carried out, except for portions removed and the insertion of windows and of doors and windows. The drawings show the building as it is now. It would not require a substantial leap of imagination to view this repurposing of the building as an unplanned consequence of nothing more than repairs and improvement.
I think you unintentionally inserted a not before require.
Apologies, my lady.
Yeah.
Yes, I'll back the court's reading skills over my own. But what the inspector is doing there in my submission is he has those plans, as we've already discussed, and he's looking at them and saying, well, the design intention here is to create a dwelling, because that's expressly what planning permission was being sought for. And it wasn't just simply speculative, because what the inspector is finding there is, well, works necessary to achieve that have already been carried out. So this isn't some subjective assessment of the appellant's intentions, it's an objective assessment of what were the plans associated with those applications show about what would be required to achieve a residential dwelling in this location. That is set out, obviously, in the context of Ground B. But the appeal decision obviously has to be read as a whole and read fairly. And so in my submission, when we then get to ground D, and we get discussions in relation to the intention of the appellant, it has to be read in the context of those findings made earlier by the inspector. And when one does that, if we look at decision letter, I think it's 40 and 41 really where the criticism arises from my learned friend. If we look at 40, the possibility that the changes to the structure deemed necessary for residential occupation, which were part of the erection of the new building, had been achieved without forethought, is too slight to be given significant weight. In contrast, the building operations carried out from 2015 to 2017 would be consistent with an objective of creating a building suitable for residential use. That intention was repeatedly stated in the 5 applications made in 2018 after those works had been completed. To my submission, what the inspector is doing there is he's assessing the actual building operation. That's what his reference is to. And those building operations are consistent with the erection of a new building. It's not some random inconsequential intermittent bits of repair. It's an objectively set out approach to the creation of a new building. And he's entitled to refer to those 5 applications because whilst the hypothetical intention of the appellant is not determinative, what he was seeking to do through those planning applications, given that they were supported by detail of how that was to be achieved, is obviously relevant in my submission to an objective assessment of the design intention of the works. And I then make the same submission in relation to DL 41. Bear with me a moment. My lady. Yes, apologies. It is DL 41. Starts partway through. Nevertheless, by 2018, and like the rest of the building, any structural and elevation changes to the eastern wing that the appellant deemed necessary for future residential use had been carried out. This must be assumed to include the replacement of roof tiles with slates. So again, he's referring to operational work that's identified as being necessary in the previous drawings and plans associated with the applications that are necessary to achieve a residential dwelling. And so in my submission, that's an entirely permissible approach, consistent with SAGE, and that is how the decision letter read fairly as a whole should be read. If I just pause there further, there's the point that, well, what actually is this building? Because the language used in the enforcement notice is, it's a new building. And I've already addressed why he finds that the new building is dependent on the roof. But what SAGE is saying is that when one considers substantial completion, that's not done in the abstract. You have to consider the substantial completion of the building before you, which requires an assessment in my submission of the very types of features that we've looked at. So actually, had the inspector not considered those various elements, he could have arguably fallen into error. I'm not saying that he would have done, but it would have been arguable that he'd fallen into error because he's not done what SAGE tells him to do, which is to consider the evidence relating to what is the design and the structure of the building intended to be. But as I've already submitted, in any event, the respondent agrees with the approach taken by Mr. Justice Fordham that the new building issue is determinative in any event, because the roof was so squarely part of his reasoning why there was a new building. Lords and my lady, there were a few points that were raised by my learned friend. There was some discussion about the opinion of Lord Scott in SAGE, but I wouldn't propose to take you to that because in my submission, what he's hypothetically thinking about doesn't arise in this case because we have clear findings by the inspector as to why he's made his conclusion, and the works that he identifies as being ongoing as recently as 2018. So this is not a case where there's been a long break in enforcement action then been taken. It was taken approximately a year after works that the the inspectors referred to as being ongoing. My lords, yes, I note there was extensive. There was review of the photographs and the witness statement and the proof evidence of the appellant. Simply make the observation that this is a legal challenge rather than a reconsideration of any planning judgments. And as we've seen in the bundle, there was competing evidence before the inspector, and the inspector didn't accept everything that the appellant said, as he made clear in his decision, and those were entirely matters for his discretion as the inspector determining the appeal. If I might just turn my back a moment. Unless I can be any further assistance to the court, those would be my submissions on behalf of the respondent.
Right. Any questions? Any questions? Thank you very much, Mr. Humphreys. Now, Miss Ollie, do you wish to reply?
I do, my lord, and I know the time. I know that.
Yes. Well, do you want to come back at 2 o'clock to do that?
I suspect I'll be about 10 to 15 minutes, but I don't want to presume on others' time.
No.
Particularly the court's submission.
Wish to hear it now? Come back at 2. Yeah. We'll come back at 2 because we don't want you in any way to feel under pressure of time. So.
I'm not under pressure, but this lady may well want to have her lunch as well as the.
Well, of course, yes. No, we take that into account too, and we think it best in the circumstances to come back at 2 in the normal way and hear your reply then.
Okay.
Thank you.
All rise.